Wiretaps played an instrumental role in Raj Rajaratnam's guilty verdict, and when it comes to an appeal, they will once again be the key issue. The defense says those wiretaps should have been suppressed, not admitted as evidence. But our next guest says that argument is a long shot. He's currently defending a case involving government wiretaps. We're joined now by Daniel Ruzumna, who is a white-collar defense lawyer at Patterson, Belknap, Webb, and Taylor, and formerly a federal prosecutor. Also with us, our friend Doug Burns. So, Dan, tell me, if the prosecution had to get special dispensation to get the wiretaps admitted as evidence in the first place, why is it such a long shot that they might not be thrown out in the appeal?
When the initial motion was made to suppress the wiretaps, the defense made a series of arguments, one of which, and the most compelling of which, was that there were alternate means available, and the wiretap was really not necessary in this case. The judge considered it. The judge did focus on the fact that certain facts were omitted from the application, but ultimately concluded, in his discretion, that that did not change the underlying fact that the wires were necessary, a necessary component of the investigation, and should be admitted. On appeal, the Court of Appeals is going to review this with an abuse of discretion standard. That's a very high standard. The judge, a trial judge, has discretion to consider the facts. In this case, he did. He weighed all the factors and ruled they come in. It's tough to appeal and unlikely to win.
What about the event that the judge did say at some points that some of the conversations that were admitted were of a personal nature? Is that going to factor in at all?
Well, you're mentioning the requirement that the government minimize those conversations that are not related to the underlying crime. They're not evidence. But again, it's a factual determination by the judge, and the judge has a great degree of discretion in ruling whether the wire should come in based on abuses like failure to minimize or failure to disclose alternative means available. In this case, the judge made a decision. It was an informed decision. He heard the arguments. He weighed the arguments carefully. The Court of Appeals gives a lot of deference to the district court.
Doug and I were talking earlier, Dan, about whether or not and to what degree wiretaps are going to play a key role in future insider trading prosecutions. Doug was of the opinion that maybe not. Maybe this is sort of the high point for wiretaps in this particular case because, what, the criminal statutes do not provide specifically for the use of wiretaps?
I agree with you. But it was interesting because where the judge may have erred, but I'm not sure because I looked at this stuff, is that the government said, look, we are using this for securities fraud, but we intend to gather evidence of wire fraud and money laundering. And Judge Holwell said, well, that's okay. But the point is, they didn't end up charging wire fraud or money laundering. So that's one issue. The other thing I just wanted to amplify on what you were saying is that apparently there was a misstatement with respect to an informant. Okay, and that came up at the Franks hearing. So Judge Holwell said, you know, that wasn't integral to my calculus of determining the probable cause. But the Second Circuit might take a fresh look at it. It's hard to say.
How much of a precedent does it set?
I think it sets a strong precedent. I agree that we will not see wiretaps in every insider trading case here on in.
They're expensive. I mean, Doug and I made the point earlier, right? Something like $52,000 to just wire up one person.
It's expensive to wire up someone, to have a constant team of FBI agents monitoring the telephone conversations. It's tremendously time-consuming, both for the prosecutor and for the agents who work on it. And there's so many other means of investigating these cases. I think we'll still not see this in all of the cases.
Can I raise another matter that hasn't come up yet? I think it's come up in the course of conversation about Raj Rajaratnam, but certainly not since the guilty verdict. Is it all worth it? 60 million bucks, right? That's what he is accused of having profited. It pales in comparison, clearly, to the damage that was done to the economy by all kinds of other ostensibly legal schemes. Is it really worth it for the prosecution to spend that much money, the kinds of money involved in wiretapping, to go after a few million bucks?
I think you can't look at it that way. I think the prosecution looks at this, as I heard Doug mention earlier, this is a case intended for deterrence. So Wall Street looks at this case. They look at Raj Rajaratnam, one of the titans of Wall Street, and say, look what happened to him. For him to make this error in judgment and to ultimately be facing now 15.5 to nearly 20 years, Wall Street's going to think twice about doing something similar.
Yeah, we heard Preet Braha, right, saying this is sort of for everybody who thinks he's too smart to get caught. I mean, he made a very specific statement.
Yeah, I mean, everybody's been saying a shot across the bow. That's, you know, and I think that's an apt phrase because, you know, we're coming after this stuff more. And even if it's not true, as you're suggesting, it puts the fear in there. And B, we may be listening to your conversations, which also may not be true, but still deterrence.
And if you think about it here, certain things that we all consider very, very private are conversations that we have with loved ones shouldn't be listened to, but conversations you have with your very close friends and longtime colleagues. Here, we had multiple cooperators who were all very close to Raj at various times, and they all testified against him. So it's a message. You can't trust anyone in this business, and you don't know what's going to happen.
Yes, that's right.
I want to tap into your personal opinions in addition to your professional opinions on this matter, because the question has been raised, is this what the DOJ should be going after? You know as well as I know, some people say that insider trading is kind of like a victimless crime. Who really gets hurt? Well, there are many examples of people who got seriously hurt by other things that...
And I'd love to get your opinion. I saw some noted economists opining that, insider trading perhaps shouldn't be criminalized. That actually surprised me, because my personal view is that insider trading is totally unfair. It gives you a totally unfair
But when we see
advantage.
it, we know it's wrong, right?
As opposed to the average investor. But your point, should they really be putting these kind of resources? I don't know. What do you think?
I think they should. I think the integrity of the market depends upon an even playing field. If information is being leaked from the boardroom into a particular fund and that fund's allowed to trade on it, it really disrupts the entire market. So it is not the cause of the financial crisis. You're right. And, one can question, should the resources be more devoted towards the financial collapse? But this is a critical area for the government to focus on. And I think it strengthens the market as a whole.
Well, and there's more to come without a doubt. Daniel, thanks so much for being here with us. Thanks.